Secretary Boying, merong legal proposition kanina si Senator Ontiveros to which you agreed. What was it? What did you agree on?
I have. Please refresh my memory. I would like to hear it again so that we can have the good gentleman.
If I may, Mr. Chair, on state witness discharge and restitution. While restitution is not a statutory prerequisite for discharge under Rule 119 or admission under RA 6981, it is sound prosecutorial practice to require it as a condition for recommending state witness status. Technically, once an accused is discharged and acquitted by operation of law, both criminal and implied civil liability in the case are extinguished, leaving the state to pursue separate civil or forfeiture actions that are cumbersome, protracted, and often ineffective. By conditioning discharge on restitution or turnover of ill-gotten assets, prosecutors safeguard the public interest, obviate the need for parallel recovery proceedings, and balance the grant of immunity with accountability. This practice ensures that while the state secures indispensable testimony, it likewise secures tangible recovery for both government and the offended parties. Mr. Chair.
To which you agreed on, Secretary Boying.
Yes, sir.
What did you agree then?
Sir,
that it is no longer...
Even though it is not found in the specific provision of the law of the Witness Protection Program, of course, there are provisions that touch upon it somehow. It is really incumbent upon us to recover as much as possible for the government in this case. And coming up with solutions such as this, asking them for restitution from the very beginning, would save us a lot of time unless we wanted to wait till the end of any litigation, which can take years before the government gets something. So that is, sir, I think that is a sound practice, sir.
How will you do that? For example, in the case of the Discayas, how much are you going to ask them to restitute?
Sir, we will need a forensic accountant to look at all their contracts, to be able to look at what was illegally acquired, so that we can ask them to return what we believe is illegally acquired.
Considering that the law is very explicit about this, that in applying for witness protection, restitution is not there, because restitution will come in only after the case has been resolved by the court. Only the court can determine how much should be restituted to the government, because as I have said, the civil liability is impliedly restituted in the criminal prosecution. So, ma-abuse mo ang discretion mo dyan, sapagkat hindi natin madidetermine. There can be abuse there. No? It's either excess or lack of jurisdiction. Let the law process take its course. Hindi yung babaligtarin po ninyo ang nilalaman ng batas. Mawawala po tayo. That is the only one that I would like to make clear to everybody. Mr. Chair. Thank you.